On June 27th, I was arraigned for the simple possession of less than 3 grams of cocaine. On that day, I fired my lawyer. Or the next day, I fired my lawyer, and I filed it to the court the next day that I wanted him fired. That was on June 27th. June 27th, 2016. The court didn't answer my demand to fire my lawyer and stuff, to give me a new lawyer or represent myself pro se until August 25th. Damn near 60 days later. That's a problem. Listen what the judge said at the hearing. Oh my God.
As your attorney, you do not want him to represent you anymore, is that correct?
Yes.
Okay.
Can I state why?
Well, you really don't need to, and for this reason. You've wanted that right from the beginning of the case. I asked Attorney LaValle to stay in, and my thinking at the time was maybe you'd change your mind. You have not changed your mind. You still want him terminated.
Whoa.
So I am...
Hold up. The judge just said, you said from the very beginning that you wanted to fire your lawyer, but my thinking was that you was going to change your mind, so I kept him on. But I see that you changed my mind, so now I'm going to let you fire him. But during this time span, when I did not want this individual represent me in no way, shape, form, or fashion, right? Due process says that I'm entitled to a probable cause hearing, a dispositional conference, which they were supposed to file for a dispositional conference immediately after I was arraigned upon the entry of my not guilty plea on on June 27th. This is a violation of due process. Listen to the judge. How he practicing law from the bench. He gonna tell me. He said it's my thinking, so I kept him on.
Yes.
Okay.
Can I state why?
Well, you really don't need to, and for this reason. You've wanted that right from the beginning of the case. I asked Attorney LaValle to stay in, and my thinking at the time was maybe you'd change your mind. You have not changed your mind. You still want him terminated.
I always wanted him terminated.
Attorney LaValle to withdraw.
What authorized you to
be excused from this hearing as well, Attorney LaValle? So, Mr. Barnett, I need you to
wait
understand that if you wish
58 days to fire my lawyer
for the appointment of new counsel, you may do so. If you wish to represent yourself in this case, I'd like you to understand that you do have the right to represent yourself. You understand that? Although it would be probably more wise for you to get a lawyer, because you do have the right to an attorney under the Constitution. You understand that?
Is the Constitution the supreme law here?
That's a good question.
It is in this court. Yes, it is.
Constitution is the supreme law in this court. I'm
So
glad you said
have
that.
the right to an
I'm gonna hold you
attorney.
to that.
My understanding is you're not applying for an attorney. So I simply want you to understand that at any point during this process, from now until the conclusion of your case, you can apply for an attorney and one will be appointed for you. Do you understand that? We're not going to have a debate about what the Constitution means this morning. I'm just telling you you have the right.
My next thing is, am I entitled to the assistance of counsel where, say if bail is denied and I'm put back in there, I can't file any motions until Tuesday and Thursday or get copies to, I don't have unfettered access to the court like my opponent. And that's...
Well, if you wish to have an attorney working for you, to file motions for you, to prepare motions for you, to advise you, then apply to the court and an attorney will be appointed for you. Understand that if you do that, the way the rules work, that attorney speaks for you. You don't speak for yourself.
Okay.
So he speaks for me, I don't speak for myself, then who's representing me?
I'll file my own motions.
Okay.
If he speaks for me and I don't speak for myself, then how he go?
Yes, absolutely. Go ahead.
The lawyer speaks for me, I don't speak for myself.
Originally, I started by asking if you had seen the indictment that was handed up on August 18th by the grand jury.
These dudes is incredible, but
Have you actually seen it?
I'm glad this is recorded because this is straight up violation of due process.
Supposed to be an indictment.
Okay. So what I'm going to do, I'm going to read this indictment to you, and I'm only going to ask you if you understand the nature of the charge. I'm not asking you if it's true or anything like that, only if you understand the nature of the charge, all right?
Yeah, not a problem.
So the indictment handed up by the Stratford County Grand Jury in August of 2016, August 18th of 2016, charges Kusha Barnett with a last known address of 41 Belknap Street, Apartment 1, Dover, New Hampshire, on or about June 24th of 2016 in Dover, with possession of a controlled drug or a narcotic drug, in that he did knowingly and unlawfully possess the Schedule II controlled drug cocaine, having been previously convicted of controlled drug acts prohibited out of the Dover District Court in the state of New Hampshire, contrary to the form of the statute. Do you understand the nature of that charge?
No, could you please explain to me what is the nature of that charge?
The nature of the charge is that you possessed a controlled drug in violation of RSA 318B2 and 26.
Nature, like,
Meaning, do you understand that the state is charging you with possessing a controlled drug?
okay.
That's the type of charge that it is. Do you understand that, yes
So
or no? Do you understand? Just answer the question first. Do you understand it, yes or no?
No.
All right. So what I'll do on your behalf then is enter a plea of not guilty with the understanding that the defendant claims not to understand the nature of the charge. So if the court would enter a plea of not guilty.
Excuse me, I'm not refusing to enter a plea. You are correct this. I'm not refusing to enter a plea on that. Is these
I didn't say you were refusing to. I said
these
that.
proceedings civil in nature, or like for a fine, or is it to take away my liberty for the next 15 years?
This is a criminal charge.
And how many years does the state of New Hampshire want to put me in prison for the possession of how many how long does the state of New Hampshire want to put me in prison for the possession of a small amount of cocaine?
The statute imposes a potential penalty of between up to 7.5 to 15 years
Where
in
say
the
that?
interstate prison.
The statute don't say that.
Fine.
Look it up.
That's the
RSA
maximum
code
penalty that's allowable under the law.
31B
So
You understand
hyphen
that?
26.
I understand, but it's still an option for you to give me the minimum is you have to give me at least 7.5 years, and you have up to 15 years to put me in prison.
That is the lawful maximum sentence. It doesn't mean that's the sentence you're going to get. That's the maximum allowable by the law.
So by law, it's still an option. If it is the minimum, is there a mandatory minimum of 7.5 years?
No,
Okay.
it's discretionary. Me.
I've never read that before, but cool.
It's discretionary with me.
Okay. So to these charges, I claim that the plaintiff lacks standing.
I'm sorry, I didn't, lack standing, okay.
That the plaintiff lacks standing to bring these charges against me.
All right, so
Can I
I understand that that's your point. This is not the time to address those issues. You'll need to file.
That's a
proper
jurisdictional
pleadings with the
issue.
court,
I'm
and,
asking,
we'll have- we'll
does
address
the
those
state of New
issues
Hampshire
in
have
due course.
standing
For now-
to bring charges against
Now that
you?
you've entered,
Like,
I've entered 4
do
years
I have-
plea of not guilty. The next issue is.
judge can't do that.
The scheduling of a trial date.
Scheduling of a trial date.
Since Mr. Barnett is incarcerated and has been incarcerated since June
Since the
27th.
24th.
That's correct. My bail order was the 27th, but you went in on the 24th. I believe that's
He's
right.
been incarcerated since he's been arrested, Your Honor.
Right. So under the Superior Court's speedy trial policy, we need to schedule a trial date within 4 months. So
4 months from the date of arrest.
Look for a trial date in that October-November timeframe.
You admitted that it's for
Now, Mr. Barnett, just so that you understand,
This judge
I'm only
does a lot of
scheduling
black
trial.
filter.
Doesn't mean that it has to go
His
forward.
words
Then
hanging.
if you need more time, you can take all the time you
No,
need.
I don't want to give my opponent no time whatsoever. I'm
Understood.
ready now.
Well, can't do it now.
I understand that, but I'm ready now.
All right.
I need.
Well, we're going to get you a trial date.
How you say it? On the phone, gosh darn it. How do I word this? All right, go to the next.
All right. So what we're going to do is look for a trial date in that. Just 1 second. Kim, if you can look at maybe November, because I think technically it runs from August, which would be
You
December.
think
but I don't want to go
technically,
that.
you don't know for sure, but the speedy
Yeah.
trial policy
Just 1
says from
second,
the date of
Mr. Burnett,
arrest. You think it's 4 months, then you said 9. Do a lot of backpedaling. If you're honest with yourself, you gotta admit that the judge is fucking up.
Is there's well, I want to raise the issue of a dispositional conference because during that time how you say when I first got to Stafford County Jail.
Just so you know, that's what we're doing right now, and I should have made that clear. So you've been
Whoa.
arraigned. This is now has become a disposition, and this is the dispositional conference now. That's why I'm setting a trial date.
Now you done fucked up.
All right.
Okay.
How is it immediately on this day you give me one? Oh, I forgot to tell you this is the dispositional conference.
Provided discovery to either Mr. Barnett or his
Can't do that, so that's a violation of
You
due
want to see
process.
discovery?
It's a violation of. I don't even.
Mr.
You shouldn't. You don't even have to listen no more
Some
because.
objections. Your Honor, I'd also like the opportunity on the record.
Oh, this is a ring. Oh no, this is trial right now.
Mr.
I forgot to tell you.
Pro se.
Nah.
Although he has
You
explicitly,
can object if you want to, but he has a right.
I understand that, and although he has explicitly said that he does not want the services of
And this
counsel,
bitch sounds
he also has
stupid. Like,
asked
she-
for
she looks
interpreters
smart, but
to
she-
help interpret the legalese and
she
the
just
legal
say some
process.
dumb
And that's
shit,
essentially
man.
what an attorney
Oh my God.
provides. It's an attorney's role. And so I would object to him proceeding pro se at this point. Also, given the nature of the charge, it is a Class A felony, especially if he's going to be asserting to his right to trial. I do just want to object on the record.
Right? Objections noted.
Now, mind